Call the first case on the docket, case number 113156, Watco Companies, Inc. v. Shane Campbell and Jerry Stanley.
May it please the court. Ken Barnes on behalf of appellant Watco. May I reserve 5 minutes for rebuttal time?
Five minutes is granted.
Thank you, Your Honor. The question before us today is how can a party be deprived their right to a trial of their issues when they have asserted a legal right, they have committed no fraud, they have done nothing illegal, and they've done nothing unconscionable. And I want to, of course, go back and talk a little bit about the time frame of how we all got here. This is a case that's been around for quite some time. It was a young man named Jack Fox who was working for a railroad in southern Kansas, and in August of 2007 he was in a position riding what's called the point of a shove, or the backwards movement of a train, and part of his duty was to kind of radio back to the engineer and tell them how far back they were supposed to back up. And as he was doing so, he lost communication with the engineer, and as he was doing that, a water truck or a box truck was coming across, and the driver of the box truck looked down at his cell phone, lost sight of what was happening, and the two collided, the train and the box truck. Luckily for Mr. Fox, he wasn't killed in the incident, but he was injured, and he brought a case against his employer under federal law, the Federal Employers Liability Act. That proceeded in federal court, and the defendant in that case, Watco, made a cross-claim against the water truck. There was no claim from the employee against the third-party defendant, Campbell and Stanley. And that case proceeded to go farther throughout the federal court system, the trial court proceedings. And shortly before trial, the parties, Jack Fox and Watco, entered into a stipulation and asked for consent judgment in an amount of $962,000, which represented less than what the economic losses from the economist in the case were going to present. Based on that, their case then was ended. Subsequent to that, they entered into an agreement not to execute, and that agreement not to execute now has become the subject of much of the dispute in this case. The federal court divested itself of jurisdiction, and the case then proceeded to be filed in Crawford County. Now, an important part of the timeline is that agreement and that consent judgment was, the agreement itself was signed in March of 2011, on March 7th, 2011, and it was disclosed to all parties in the federal trial court within 2 or 3 days. By the time this case was out of the jurisdiction of the federal court and back in state court in Crawford County, the parties had that agreement and had known about the consent judgment for quite some time. In the Court of Appeals opinion, there's some discussion about rattery and the duty to notify the court and parties about settlement agreements when they're a Mary Carter variety and you're trying to execute on that Mary Carter type of agreement. And in this particular case, at the trial court, at the federal level, of course, they already had the agreement and the consent judgment. When it came down to the district court in Crawford County, the petition was filed on July 1st of 2011, and 24 days later, a copy of that agreement was attached to the defendant's answer. So the court, in federal court, had the agreement months before. All the parties had the agreement from March, and the trial court in Crawford County, Kansas, had the agreement 24 days after the case was filed. And the Rattery Court has said that when you are going to have this type of agreement, and they said this type of a Mary Carter agreement is acceptable, that the court and parties have to be promptly notified. And so in this case, the parties were notified within 3 days of execution, and the court was notified within 24 days of the filing of the state court case. And of course, everybody knew about it, the agreement, well before the case got there.
Notified by the other side.
They were. It was attached to their answer.
They were non-parties to the agreement.
They were non-parties to the agreement. The defendants attached it to their answer. And that was about 3 months before a judge was even picked in the case. And so the agreement was a known entity, if you will. And the Rattery Court rule was designed to keep agreements like this from being kept secret and not available at the trial of the matter, so that a party who is defending themselves against comparative implied indemnity, as we have in this case, should have the benefit of having that agreement so they can use it at trial to cross-examine who was the defendant in the first case and who's presenting evidence in the case for comparative implied indemnity. And in this matter, the trial court and the parties had the agreement in July of 2011. The case was dismissed on the grounds of unclean hands in December of 2014. So you had it for 3+ years. The party and the court knew about it well before trial.
This seems inconsistent with your objection to the use of the copy of the agreement that was attached to the answer.
Yeah, and I want to brought that up. The agreement that was attached, it wasn't an objection to the agreement that was attached to the answer. The objection was to a part of the agreement that left out page 3, and that's noted in the record. And our objection centered mostly around that. If you're going to use an agreement and you're going to use it to support summary judgment, you ought to authenticate the agreement. You can't authenticate an agreement if you're giving part of it and leaving part of it out. And that was what was presented to the court on the summary judgment motion. But the right to seek comparative implied indemnity didn't really vest with the agreement. The right to seek comparative implied indemnity vested when the two parties to the FELA action entered a lawful stipulation of damages and asked for a consent judgment. The agreement that has been so often discussed was a contract between those two parties on how they would resolve the eventual recovery back from Stanley and Campbell.
But that contract didn't include an assignment, did it?
It did not.
Fox's rights?
It did not. There's no assignment in
So
that.
how do you have standing to assert the damages of Fox?
The damages of Fox become the damages of Watco, just like the damage to their train, which was part of the underlying case in Crawford County.
I would understand that with an assignment, but absent an assignment, how does it occur?
Under the Golden case, which says when you pay as a railroad under an FELA case, you can then have a separate proceeding where all of the fault is compared. That hasn't happened yet. And you can recover over from that third-party defendant, which is precisely what was trying to be accomplished here. Watco did pay a certain amount of money toward that consent judgment, toward the $962,000. They also paid medical bills, and they also were out some expenses related to damage to their train and property. Those are all right and salient and should be allowed to be recovered against Stanley and Campbell once it's proven that they have 51% or greater fault, and all the fault of the parties is compared. That's what Golden stands for. And the arguments from counsel have been, well, this is too high of a number, that type of a thing. The lower court in Crawford County has already said, which is proper under Rattery, that the agreement is going to be brought into court and it's going to be presented, and that the defendant in the case, Stanley and Campbell, will be allowed to challenge the reasonableness of the agreement, and the trier of fact will be able to determine just exactly what Watco is entitled to recover. Are they entitled to recover the amount of the consent judgment, for example? Are they entitled to recover the $200,000 cash payment, for example? Are they entitled to get some comparison of both of those things and also their property damage claim against the defendants?
Well, can you point to a Kansas case that asks a jury to determine the amount of damages suffered by someone who's not a party to the case? Where is that? This is really a negligence personal injury claim, isn't it?
I don't believe it is, because...
Why isn't it? I mean, why isn't it just a personal injury claim in which you claim negligence, and where Mr. Fox is not a part of this case?
Because we're now talking about what has Watco, what are they out? What are their damages in having to pay what is ultimately the fault of Stanley and Campbell? That's what the Golden case stands for, is the comparative implied indemnity for what Watco is out. And so the fact finder...
Watco's out $200,000, aren't they?
They're out $200,000 cash.
And then you're asking for like $700,000 more at least.
Well, Watco is out there, have a consent judgment. If you look at the affidavit from their counsel, they still deem that they owe the entire remainder of the balance. So the question is for the finder of fact is, what are the actual damages of Watco? Are they the amount that was paid by cash? both for Mr. Fox's damages and the damage to their equipment, or is it the amount that they have and are subject to a judgment? That would be a fact finder question. Not unlike the Martinez question, where we submit, and this court found, when you have medical bills submitted, you can submit to the jury for finding of fact, is the proper amount of damages the amount billed or the amount paid? Both go to the jury for consideration. It is determination of fact. And that's what we're asking the court to do here, is allow that proceeding to go forward and let a fact finder determine, just as your question asks, what is Watco's real damage? Not what are the damages of Jack Fox, what are the Watco damages?
Am I correct that Watco, under the agreement, there's no way Watco will pay back to Fox additional sums unless they recover those sums?
Correct. If it's found that the 900...
So Watco's really not out any of those hypothetical damages. The measure between 200,000 and whatever it is, 960 odd thousand.
That is correct. If they got an award for $960,000 and 99% of fault was on Stanley and Campbell, the majority of that would be kicked back over to Mr. Fox. And if the case had proceeded to trial...
But that's not a damage. I mean, your client's not suffered that amount because there's been no recovery.
They have not paid that amount. They have not paid that amount. They have suffered a
and they
consent
never will,
judgment.
right? There's no circumstances under which they would pay that money unless they recover it against the third party, right?
That's right, but they owe it. They owe it now according to a consent judgment, and they've agreed not to execute on the consent judgment unless and until
So the
this
owing
case
is
over.
just a pure legal fiction.
It is a agreement to not execute on the judgment. It is a judgment.
It'll never
that
be
stood
money
says.
out of their pocket.
I'm sorry.
It'll never be money out of Watco's pocket.
Well, it would flow to their pocket and then out of their pocket to Fox. And so let's talk through some hypotheticals as the court has now propounded them. Let's assume for a moment that instead of this case being all three parties joined, Fox and Watco could have settled the case for $960, and then Watco could have gone after Stanley and Campbell, and if they got a 99% or 100% fault on Campbell, it would be the same effect. They would have no money out of pocket because they would have recovered it all from Stanley and Campbell. And is the agreement written as best as it could be with hindsight? No, I will spot for the court it is not. However, the impetus of it was to try to effectuate the golden right, which is Watco's ability to get back what they're out, their damages, from what they believe and perceive and have always maintained in all of their filings is the real bad actor, the one that committed the most negligent act in this particular fact pattern, in this particular case. And so that's... I'm sorry?
Do I understand that part of this lawsuit is a property damage claim that Watco has against the defendants?
That is correct.
And if Watco collects on the property damage claim, does it have to pay that money over to Fox?
It would seem not. I mean, the agreement, again, was silent on that issue, but it talked about a personal injury claim, so it would seem...
Well, but it was ratcheted based on recovery, and it seemed like recovery could be broad enough to include the property damage, so in effect, you're giving up some of your property, you're giving up your property damage claim, potentially, to pay it over to Fox. Is that a fair reading of this thing, this agreement?
I don't read it that way because it references a personal injury lawsuit between the judgment references a personal injury lawsuit, and that when Watco recovers back based on the negligence that they're not. I don't read it that way. I understand it to be that the medical bills that Watco's out, the train damage, the equipment damage are still very much their own damages, which would not be assigned over. The separate then line item, as I would see it on the verdict form, would be for the amounts that they either paid or owed to Fox, which would be that question of fact, again, between the 200 and the 962.
And if Mr. Fox had never filed his lawsuit, never made a claim, Watco could never sue for those personal injuries.
If Fox had just, never made any type of a claim,
Right.
that's correct. Or another scenario, and many times I've been doing field work for a long time, and a lot of times these cases are settled early on. And if for example, Watco and Fox would not have ever filed a claim, and they had settled the case for whatever kind of a Mary Carter agreement or however they wanted to settle it, then Watco would still have the right under Golden and comparative implied indemnity to go after the amounts of that settlement. Defendants, much like they can here, I think would be able to challenge the reasonableness of that resolution. And the trial courts, of course, order that that's going to take place if and when this case goes back to the trial court. They can challenge the reasonableness, but the right of Watco to go after Stanley and Campbell for comparative implied indemnity would exist even with a settlement if there had been no filing of the personal injury or the FELA case between Fox and Watco.
The Golden Rule is worded in terms of bringing a party into the action. It seems consistent with Kansas's single action rule. You, however, are involved in a second action. What in Golden or what other source do you have that can convince me you can bring a second action?
And in Golden, I think they said they want to compare fault in one action. Whether the case I believe it dealt with, and it drew on Kennedy, was that you could bring them in the same action, but the one fault rule, I think, is what they're talking about, the comparison of fault in one case. And that simply has not occurred here. We see this as if this case goes back to the district court, one of the issues for the finder of fact to determine is the relative fault of all three parties. That hasn't happened so far. It's one of the things we are asking and we are seeking this court to allow to occur, which is a determination by a finder of fact as to the fault of Fox, Watco, and the Stanley Campbell defendants in this case. And that way that comparative fault analysis occurs.
Any more questions?
Yeah, I want to clarify what was settled, because there was some discussion about damage to the train, etc. The original suit, Fox sued Watco, sued his employer for damages he received. He didn't sue for the damage to the train. I mean, the train damage wasn't part of that lawsuit, was it?
Well, it was in the cross-claim by Watco.
Well, yeah, and Watco's cross-claim against Campbell, but you didn't settle that.
We did not.
You settled what you settled with the agreement was Fox's claim against Watco.
Correct.
Okay, so I don't understand why we're all unsure about the train damage, because that was never settled. So far, that's never been settled, right?
That's correct.
That's not part of the agreement that you're trying to enforce in this state court action, right?
That is correct.
Okay.
And that was all part of what was filed originally in the federal court and also in the district court of Kansas. Where
We have two courts that found that this was unclean hands in pretty graphic terms, especially in the Court of Appeals. Why are they wrong?
Well, I think we have to look at what it takes to have unclean hands. And, if you look at, for example, the case law that they rely on, and if you read that opinion, with due respect to the court, it seems to have some factual inconsistencies. For example, they say a number of things. They say that it is that Watco had the legal right, that they preserved the right, that they were the real party in interest. They say they go into great depths to discuss Mary Carter agreements and the legality of those, and that they had the right to enter into that. And then they go into a reinterpretation of Ratterley that really doesn't exist. They say that one of the reasons that it is unclean hands is that it wasn't attached to the petition, and that is not found anywhere in the Ratterley opinion. The Ratterley opinion says simply that it has to be promptly provided. It has to be promptly shared with all the parties in the court.
When did your client plan on doing that?
Well, in this situation, when we filed it with the district court, understanding that it was now 4 months after all the parties, including the Stanley and Campbell defendants, had a copy of the agreement. I can't look back and tell you when it was going to be provided specifically to the district court in Crawford County, but it would have been provided, and it was certainly discussed at various points at length in motions and hearings and discovery and all of those types of things with the district court over the course of about 3 years. So the district court had it 24 days after the case was filed, and to my mind, that would indicate promptness. There was no attempt, and there was no attempt by Watco to have it stricken from the answer of the defendant or anything like that. The court had it, and it was prompt under any sort of Ratterley analysis. And if you look,
But what about the structure that essentially allows a scenario where you're out nothing?
Well, there, you know,
That could certainly happen in under the structure of this, and how is that tolerable? And I think there's offense taken by that by both the trial court that ruled on this and the Court of Appeals, and I think that's really the crux of it. Is the structure of it also?
you know, and if I may have just one brief moment on that, you know, I think we look at the Kansas court opinions on unconscionability in contracts. The only two parties to that contract that are bound by it are Fox and Watco. Are the terms of it not the best written? I've spotted for you that they are not, but there's a ton of cases.
Well, they're completely self-serving on Watco's part.
And that would be a challenge upon the remedy. And so the right, though, to bring a claim for damages related to what you've paid out under comparative implied indemnity and Golden exists, but those are attacks on the remedy. And if we look at the record below, Campbell Stanley gets to challenge how much value Watco is truly out. That's one of the rulings of the trial court, and that's what's suggested by the Ratterley court as the remedy in situations like this.
Which is why I get back to why isn't this just a personal injury lawsuit that you're sitting in for Fox?
You know, I don't view it that way because of the posture of the parties, and I think the question for the jury, should this get back to the court, would be how much are the damages of Watco, and they're going to have to assess that. And if it is, the Learned Counsel will have an opportunity to attack the 962 consent judgment, and one of the other tags for that is the check that was written for $200,000 would be another measure of damage, and also the damages to the train and the property and the equipment, the medical bills that were incurred, those types of things. We're just asking that a finder of fact get to hear that evidence and make that determination, and then allocate the fault among the three parties, or non-parties as they may be at this point, but the three actors in this case, which would be Jack Fox, Watco, and the Stanley Campbell defendants.
Any further questions? Thank you, counsel.
Thank you.
Dana M. Harris for Appalese, Shane Campbell, and Jerry Stanley. The appellants in this case are still in denial, having been admonished by three separate courts, and they're still in denial. I would like to point out to the justices that they fought our discovery of the emails that led, that provided information about what led to this agreement. For example, those emails revealed that as late as a few days before the jury trial, the plaintiff was willing to settle for $300,000. Their last formal demand was $425,000. Watco's last offer, in combination with Campbell and Stanley, was $175,000. I would also point out that in the Crawford County District Court, they're now saying, well, Campbell and Stanley get their opportunity to challenge the reasonableness. That was not the position that they took in that case. They took the position in that case that we were bound by the $962,000 collusive judgment. That's still their position today. And in fact, as you saw in the Court of Appeals, they didn't want us to use the agreement. So in answer to a question that was asked, when were they going to provide that agreement to Judge Jack? I think the answer to that is they weren't, because they didn't think it was relevant. They thought they had a $962,000 judgment, and they thought they were going to stick it to Campbell and Stanley. And I'm convinced that when that agreement was hastily drafted back in 2011, as we were on the eve of a relatively simple personal injury case that would have now been over 7 years ago, that they thought that Campbell and Stanley were going to be bound by that judgment. I think they thought that. They hadn't read the Kennedy case close enough. So I think that Watco and Mr. Fox thought that they had put together a mutually beneficial collusive agreement that wasn't going to be challengeable by my clients, and that Watco was going to eliminate its responsibility for its fair share of comparative fault, while Fox, who did not bring an action, had an opportunity to. We were brought into the case within 2 years of the accident. Fox could have asserted a bodily injury claim against my clients, but chose not to do so. So the only reason we were in the federal court was for the comparative implied indemnity claim of the railroad. Having said that, that case proceeded along through discovery, and the railroad did all kinds of discovery on damages, and we were right there with them. They took the lead on it. We had pretty much agreement that the plaintiff's damages were exaggerated. We were ready to go to trial. And then on a Thursday or Friday afternoon, we're hit with this agreement. So had this case proceeded as normal, we would have tried it in the spring of 2011, 7 years ago. And absent some legal issues, the case would have been over. But now my clients are here 7 years later, and they still want to go back and try the case.
What's
I'm sorry.
What's our standard of review of the clean hands finding or the application of the clean hands doctrine below?
I think it would be de novo.
There's reference in the Court of Appeals opinion to the discretion of the district court to apply what amounts to equitable estoppel.
Well, there is reference, and it is discretionary with the court, but having reviewed the cases, I originally thought it was an abusive discretion standard. And then I became convinced that right before the Court of Appeals argument that it was de novo because it was summary judgment. So
That's right. It's at the summary judgment stage.
it's kind of a hybrid situation, and I could be wrong. It could be an abusive discretion standard, but as I stand here, I was operating under the assumption that it was de novo and that the court could look at all of those issues again. And the questions raised by the justices here today, a lot of them relate to the real party and interest issue, which Court of Appeals apparently did not agree with Judge Jack on. We agree with Judge Jack that not only were there unclean hands, but in fact, Watco is not the real party and interest on this particular case. And I'll also address this Mary Carter agreement issue because with due respect, I think the Court of Appeals, although their ultimate finding was correct, we don't think that this is a Mary Carter agreement, and I'll explain why I think this agreement is much more pernicious than your average Mary Carter agreement. First of all, as to real party and interest, the Torkelson case, cited in our Court of Appeals brief, states the general law that the real party and interest is the one entitled to the fruits of the action. So what we have here is a plaintiff in a bodily injury action, Mr. Fox, who's blown the statute of limitations against my clients. And on the eve of the trial of his FILA claim against Watco, where we're only in under comparative implied indemnity and would owe Mr. Fox nothing, he puts together an agreement that is not a traditional Mary Carter agreement where there's two defendants against whom both plaintiffs have a claim, and you go to trial and the jury is told that one of the defendants has settled out, and then the plaintiff proceeds against the defendant. That could not have happened in the federal court here because Mr. Fox had no claim against my clients. But what they did was put together an agreement that not only was designed to eliminate Watco's true responsibility, it transformed Mr. Fox. It took his barred claim and made him the plaintiff against my clients in a claim that otherwise would be barred by the 2-year statute of limitations. Not only that, but he didn't even have to prosecute the claim because, as I stated, their position has been that that $962,000 judgment should not have been subject to challenge.
To get down real simple,
Yes.
you're saying that it's not a Mary Carter agreement because Fox, the injured party, never had a claim, a valid claim against your clients, the defendants. That's what takes it out of the traditional Mary Carter agreement scenario.
That is one reason. And another reason that it's taken out of the traditional Mary Carter arena is that in a Mary Carter case, by definition, the remaining non-settling defendant is going to trial and having their day in court on the damages, versus in this case, the settling defendant went in and engaged or agreed to a collusive, inflated $962,000 judgment that they thought my clients were going to be bound by. And that certainly is well outside the normal Mary Carter scenario that one sees, and that's why I disagree with the Court of Appeals analysis that this is some kind of sliding scale Mary Carter. I certainly agree it's a sliding scale agreement that's designed to profit both Mr. Fox and eliminate Watco's.
On the sliding scale, I just have a clarifying question.
Sure.
About the $200,000. Was that paid to Fox?
I believe it was.
Okay, because there's that paragraph, I think this is from the district court's order. I'm looking at paragraph 7, where the district court says that $200,000 is the most Watco would be liable for, but, quote, would potentially pay Fox nothing, which that just leads me to be confused about whether that $200,000 was actually paid or whether it was only a contingent payment.
I'll defer to
That's fine.
Watco at Fox, but I believe they did pay it, and I think that potentially liable.
So that
I can only assume that what Judge Jack meant was that ultimately they might be liable only for that $200,000 they already paid.
well,
But under the
that's
agreement-
not what it said.
I'm sorry.
Again, just looking at paragraph 7,
Yes.
it would seem to me that your answer would indicate that at least that sentence is inaccurate. About potentially paying him nothing.
Oh, no. Well, I think that's a semantical situation. They would
You think he
potentially get
Get it
their
back.
$200,000
Yeah.
back.
Get it back.
So in effect, I think it's a semantical situation. In effect, they would be paying nothing because they're getting
That makes
reimbursed.
sense. I appreciate that.
Okay, thank you.
When you say Fox had no valid claim against your clients, what was the status in federal court of your?
The status in federal court.
You were brought in by Watco,
Correct.
and wasn't that a claim then against you as a defendant?
Only by the railroad. Mr. Fox did not assert any direct claim against my clients, and my clients would not have been liable for any damages directly to him as the result of that trial. They would have been liable only potentially for under the comparative implied indemnity, which in essence meant they would have paid whatever to the railroad, who would
Then would have.
so.
Okay.
I want to discuss the Green versus Higgins case for a minute, which is the unclean hands case, which I'm sure the court's familiar with. The plaintiff in their brief tried to make a point of the fact that the court in Green versus Higgins mentioned that the fictitious real estate agreement that was at issue in that case was illegal. And they say, well, we didn't do anything illegal here. And I would just remind the court that the unclean hands doctrine is stated in the disjunctive. It is fraudulent, illegal, or unconscionable. So while this may not have been an illegal agreement they entered to, although one might argue it should be, it certainly was unconscionable and it certainly was fraudulent, just as in the Greens versus Higgins case. And I would ask the court, in considering the Green case, what is the distinction between creating a fictitious real estate contract with an inflated sales price that convinces someone who has a first right of refusal not to exercise it, versus putting together an agreement which eliminates the responsibility of Watco that it otherwise would have under the comparative fault laws, and potentially results in a windfall to the plaintiff against my clients that he otherwise would not be entitled to because the statute of limitations bars the claim.
Didn't the federal court approve this agreement?
The
And
federal
what do you
court-
make of that? They had the Judge O'Hara had the agreement, saw it, it just looks like raised his eyebrows or however you want to characterize it, but he ultimately approved the agreement.
He
Well,
ultimately,
what do we make of that?
he ultimately accepted it with the statement that the arrangement raises a host of practical and ethical issues that Fox, Watco, and perhaps most importantly, their experienced trial lawyers do not appear to have fully and carefully evaluated.
But he,
But now it's our problem. That's what it amounted to. I mean,
Well, it's your issue, certainly. And
it's just unusual. You would agree, I'm sure. to
there
have
is,
the
there,
approval.
this is an unusual case that has consumed about 20% of my rather lengthy trial career, so.
7 years.
And a little bit different than anything else I've ever seen in my career.
so.
And hopefully you're going
what-
to put an end to it. I
What,
think.
what you're saying is he handed off something that was unclean, or did he approve the It sounds to me like he,
I don't think he had any choice. If a
well,
defendant comes.
couldn't he have said, no, this is what you say it is. This is reprehensible, this is conduct that is not acceptable for the reasons you outlined. Judge O'Hara could have done that.
The problem is that we looked into it, we wanted to challenge it, but we didn't have standing because we were only there because of the complied indemnity claim. So unless the judge, and they presented that economic plan they had that showed $1 million worth of damages to try to show that somehow this $962,000 judgment was reasonable. I can't cite you any case law that says that Judge O'Hara had the right to say, no, I think this is not right, and I'm not
Well,
going to.
presumably Judge O'Hara did not have access to the materials that you obtained via discovery.
No,
Is that
no,
fair?
he was not aware of all the medical information or anything else, and we didn't get to make a
Or of-
presentation to him that this was an inflated amount.
Or of the information that arguably at least, or that the lower courts seem to have relied on to suggest that this was a collusive agreement on inflated damages.
Correct. He was unaware of the email exchange.
That's what
that
I'm
we
referring to.
eventually forced them to produce that showed the corrupt negotiations that led to what I would describe as a corrupt agreement. Judge O'Hara was not aware of any of that. All he was aware of was the sliding scale and the fact that they claimed $1 million in damages and he had a $962,000 judgment. I think the thing that concerned him the most.
Counsel, can I ask a quick?
Yes.
Just a kind of a practical question. How did the approval work practically? Were you present when it was approved? Were you included in any way when it
No.
was approved? Okay. was just
Again, I can
presented
tell
to the
you that
judge outside your
we
presence.
very much wanted to challenge it, but based on our research, we just didn't feel that we had standing to do that.
Even though it exposed you, you just weren't included at all at that
Correct.
juncture.
Because if we had been a defendant, perhaps we would have had standing, but again, if we weren't
defendant
absolutely
vis-a-vis Fox.
convinced, I'm sorry?
A defendant vis-a-vis Fox as
Yes.
opposed to a third-party defendant.
We were absolutely convinced that we didn't have standing, otherwise, we definitely would have been challenging it. And Judge O'Hara, I think his biggest concern, based on the information he had, was that Fox was going to jump in the shoes of Watco and then pursue a claim against us. I think that was his main concern, based upon the information that he had at that point in time, which is exactly what's happened. Since 2011, when this was refiled, the only communications or activity I think that's come from Mr. Church, who originally represented Watco, is he showed up at the Court of Appeals, and I think he's here today. But everything else has been handled by Mr. Fox's attorney, now Watco's attorney, Mr. Barnes. So this is Mr. Fox and his lawyer sitting at this table. It's not Watco. Watco is basically a third-party beneficiary sitting back watching, hoping that Mr. Fox collects a lot of money so that they can get out of their $200,000 settlement obligation. That's what's going on. And for that reason, based on the Torkelson case, we don't believe that Watco is a real party in interest, and the case should be rejected and dismissed. Summary judgment should be entered for that reason, and also based upon the unclean hands doctrine. Either one.
As a matter of just legal theory, which of those comes first? Standing or equitable estoppel? Or does it matter?
Standing, I think the real party in interest would come first, but then if you're not going to grant summary judgment on that, I think the real party in interest is still a part of the unclean hands analysis in terms of them putting using this agreement to put Mr. Fox in the shoes of Watco to pursue this bodily injury claim. So, but pecking or order-wise, I suppose real party and interest.
You
would be
think we
first.
would have to decide the standing question first and then move on to the real party or to the equitable question?
No. I suppose you could not address the standing issue and still grant summary judgment on unclean hands.
Or vice versa.
Yes, either way.
Any further questions?
That depends on whether standing subject matter jurisdiction, right?
I'm sorry?
That depends on whether standing dictates subject matter jurisdiction.
Yes, and this is not your typical sort of real party and interest, because I suppose Watco has a little bit of interest in how well Mr. Fox does, so.
$1,200 worth of its own damage.
Yes, and I regret that I'm not prepared to address the Watco property damage argument, because I have not been focusing on that, so, thank you.
Can imagine.
Do we have any further questions? Thank you, counsel.
Thank you.
May it please the court?
Yeah, start off with the observation that this agreement really does twist the traditional safeguards that are a part of the adversary system. First, you're a defendant, and I assume you're trying to mitigate and minimize damages, and now suddenly you're in a posture that now you're trying to maximize the damages as much as you possibly can, which seems that you really are a defendant in this case, aren't you?
No, Your Honor, I don't believe we are.
Originally you were
in the original case, Watco was the defendant in federal court, sued by their employer.
Sued by, and you were trying to minimize the damages that were associated to Mr. Fox.
Absolutely, that's absolutely true.
And so now you're in the complete opposite posture and attempting to maximize the damages.
No, I would say that the agreement that was entered minimized the exposure to Watco at the time because there was over $1 million in economic losses, and the Fox claim was, I think, submitted at $3 million is what they were going to ask for at the district court level. So it bought some certainty, similar to what we see in other cases that Golden, for example, anticipates. So the minimization, if you will, bought some peace for Watco at the time that they did the consent judgment in an amount much, much, much less than what Mr. Fox was seeking. And I'd point to, in that case, that they were bound by federal law. The employee got to a very small burden of proof under the FVLA. And then the trial court at the federal level denied, a summary judgment motion of Watco, which exposed Watco then to damages and to a verdict under the Locomotive Inspection Act, which all the jury would have to find is that the radios didn't work right at the time, and they would instantly be found liable. Those were issues that were concerning to Watco and entered the discussions and their analysis of whether or not this was a good way for them to avoid what could be a $3 million or more verdict against them. So I wanted to correct or actually answer your question about the payment. Watco did write a check for $200,000 to Mr. Fox, absolutely. As to the right to comparative implied indemnity, that exists because of the damage that Watco believes, the damages that they incurred because of the negligence of another party. That's what Golden stands for. We only ask that the trier of fact be able to consider all that and say, here are the amounts of actual damages that Watco is entitled to because of the fault of Stanley and Campbell. If Stanley and Campbell found to be 99%, no matter what the number is, Watco should be able to recover that over that 99%. I mean, we have a situation here where we have a stipulation and admission that the driver of a commercial vehicle was using his cell phone, dropped it, looked down, and wasn't paying attention to the road. And I think Watco, since they have incurred losses, since they have had to expend money, under the Golden scenario, they should be allowed for a jury or a trier of fact to compare what that fault is versus whatever might be perceived as fault for a radio malfunction or any other claims of negligence that might exist. That's what we're asking this court to do, is to allow that comparison of fault and let the finder of fact determine how much are Watco's damages? How much did they incur as a loss as a result of the negligence of Stanley and Campbell? That's what we'd ask.
The answer to that question is $200,000 at most.
It very well might be, Your Honor, and that has not been.
How could it be any more?
The question would be, is a consent judgment where you're exposed to consent judgment for more, does that expose you, is that sufficient for you to make a claim? And that determination
What's
is
the
not
exposure?
Pardon me?
What's the exposure?
The exposure is to that consent judgment. And Mr. Hayes, who
Which
was...
can't be executed on.
It can't be executed unless they recover from somebody else. The answer to your question, I spot for you, Your Honor, it may very well
Which
be.
then gets us back into, I mean, I'm still hung up on real party and interest, and I'm not sure you get to make any of that claim, but it seems like at most, all you've got in the pot is $200,000.
Your Honor, that might well be. And I think to the argument on real party and interest, the strongest part of their argument would be to anything in excess of what was already paid. But there's no case law in point. It's a case of first impression on whether a stay of execution on a judgment, whether you can go after that entire judgment. I referenced the Martinez case because it was the only thing that rung to me somewhat analogous, where the amount that is billed or is submitted and then a trier of fact determines how much the damage is.
Let me read you a line from the Court of Appeals opinion.
Yes.
There can be no dispute in this case, no matter how hard Watco tries to create one, that based on the agreement, the most Watco will ever have to pay is $200,000. And so why is it, I mean, your answer to Justice Biles is that may well be. But why isn't it, no, that what the Court of Appeals says is right?
Well, and what I was answering was, is Watco limited to the amount that they've already paid? And to answer your question...
Right, and I mean, here's the Court of Appeals saying there can be no dispute, no matter how hard you try to create a dispute, and I see you trying to create a dispute here, right here. And I just don't see it. I mean, how can you argue that you might be liable for some amount beyond $200,000?
And it goes back to the consent judgment, the stipulation of damages. And if Watco were to recover those from Stanley and Campbell by execution of the contract, as tortured as it may be, the money would come from Stanley and Campbell to Watco, and then they would be duty bound, is my position on the contract, and then pay that over in accordance with the agreement to Fox. So I guess the answer to your question is, and the question for all of us perhaps is, does that mean that Watco's paying money over or not? And isn't that what comparative implied indemnity allows one to do, is to, for example, let's say this had gone to judgment and there was a $900,000 judgment, and all that was tried was the Fila case, which is perfectly permissible. And while that case was on appeal, Watco went after Stanley and Campbell and got a judgment, and they were found to be 100% at fault. You'd sort of have the same fact scenario in that ultimately the money that was owed from the defendant, who's mostly or wholly at fault, Stanley Campbell, would be used to satisfy the Fila claim. And so you would still have that sort of fact pattern, if you will.
But with different rules, wouldn't you?
I'm sorry,
With different rules, because of the FILA burden of proof that you discussed, is not the same standard that the other defendants are held to.
Yeah, you raise a good question, because had the case gone to trial in federal court, and to correct one more part of the record, at the time that the judge accepted all of this and entered the judgment, all of the parties were on the phone and were in the hearings and all of those things. But had that case continued to trial, it would have been very tortured jury instructions, because you would have had this lower standard for the FILA, the FELA, an even lower standard for the Locomotive Inspection Act, and that would control the relationship of Jack Fox to Watco. And then you would have had some crafting of a jury instruction of Watco versus Stanley and Campbell, and the jury would be tasked then with trying to figure comparative fault with three really competing laws, two federal laws, and then general negligence law under Kansas state law.
And you're suggesting that the FILA stuff does not transfer over to the comparative implied indemnity?
You know, that's an interesting question. How much fault is put on Jack Fox at this trial is still going to be a tough question of jury instructions, because you still have those issues. How much fault can an employee have under the FELA? I guess one can argue that they would be asked, the jury be asked, does he have any fault related to Watco and Stanley, and we fall under general Kansas negligence law, I guess that's potential. But it's going to be, that's a difficult in this sort of a scenario because of the interplay of the federal and state court laws.
Have any further questions? I see none. Thank you, counsel.
Thank you, Your Honors.
We appreciate the arguments of all counsel on this case. Court will take this matter under advisement.